Hello everyone, and welcome to our ITCL webinar on the importance of soft law and standard contracts in commercial arbitration and litigation. This is a very special occasion for us. We are celebrating the 40th anniversary of the Center for Commercial Law Studies, and we found that perhaps the best way to do it is to organize some sort of a roundtable discussion on one of the most classic themes in commercial law scholarship. So I'm very pleased to moderate this discussion, and without further ado, I would like to extend a warm welcome to our distinguished panelists for this lunchtime webinar. Raid Abu-Manneh from Mayer Brown International, Domenico di Pietro from Bryan Leighton Paisner, and Sam Prentki also from Mayer Brown. Before moving on, please allow me a short parenthesis just to note that we are having a Q&A session towards the end of the webinar. So please do submit your questions on the Zoom chat so that I will be able to see them. And we will try to cover as many questions from the audience as possible. Well, I'm closing now the parenthesis, and I would like to turn to my panelists and ask them to briefly introduce themselves. So, Raid, thank you for joining us this lunchtime. Could you please tell us a little bit about your professional background?
Yes. A very real pleasure to be here with you today. And first of all, the most important thing to mention is I'm a Queen Mary alumni, and I was taught as well by Professor Roy Good, who established and created the centre. So this is a great privilege to come back 5 years later. No, I'm underestimating it, but a few years back, and to talk to everyone at Queen Mary. So I'm the global co-head of International Arbitration. I'm the head of International Arbitration in London. I'm also a member of the construction practice. I started my career as a construction lawyer in London. And so the sort of emphasis and comments that I'll be making in relation to soft law will be from that perspective, in a sense, how I see soft law being used, particularly in large infrastructure arbitrations.
Thank you very much. Domenico, a few words about your legal background and expertise.
Thank you, Andromachi, and hello, everyone. And also, I would like to echo what Raid just said. It's a great privilege to be involved in this celebration today. I'm also a former student of CCLS in a way, because I did my LLM at the School of International Arbitration at Queen Mary. And so I have very happy memories of my time as a student. And in fact, I remember reading one of the first articles that I read when I was studying at the campus in Milan was an article by Roy Good on reflections on the harmonization of commercial. So this, webinar today really brings me back to the happy times of when I was a student. Sadly, I'm no longer a student. Now I practice international arbitration at BCLP. I'm currently based in Miami, and my practice is entirely focused on international arbitration, both commercial and investment arbitration. I trained in Italy, where I qualified, and I traded again in England and Wales, where I also qualified as a solicitor. Occasionally, I sit as an arbitrator, but most of what I do is work as counsel in international arbitration proceedings.
Thank you very much, Domenico. Sam, welcome to this afternoon. A few words about yourself.
Hi, Janaki. Yeah, likewise, it's a great privilege to be able to speak to you all this afternoon. I am a member of Raid's team. I'm a senior associate in the International Arbitration Department and also the Construction and Engineering Department. I'm not quite an alumni, but I like to think of myself as an extended alumni because I went to the University of London to UCL. So I'm also not too far removed, and I live just off the Whitechapel Road for a while, so not too far away either. Yeah, this afternoon, my perspective will be obviously very much from international arbitration perspective as well, but also I've spent a long time in formal litigation. So I will also try to look for the litigation angles a bit more to balance up the arbitration bias that we obviously have amongst us.
Thank you so much. May I also add that I happen to be an alumni of CCLS, but apparently I decided to, to take an academic turn in my career. And here I am moderating this webinar this afternoon. And like you, I have very vivid memories, and I do remember how impressed I was realizing the variety of the teaching and research curriculum at CCLS. Definitely I was at the right place and at the right time pursuing postgraduate studies in the field of commercial law, broadly conceived. So with these remarks, and as I noted already, the importance of soft law and standard contracts is a classic theme in commercial law, both in common law as well as civil law jurisdictions. And of course, there are all sorts of different ways to approach this multidimensional issue. And most probably, we would need an entire day to make justice of the richness and complexity of the relevant debates. But for present purposes, I think that we can at least begin to examine the importance of soft law and standard contracts by trying to map the relationship between the two. So I guess my first question to the panelists is the following. Drawing on your experience in international commercial arbitration and litigation, how would you describe this relationship? For example, is the relationship of companionship or conflict? And why? And I'm also wondering whether soft law and standard contracts receive different treatment depending on whether the parties choose arbitration to litigation proceedings to resolve their disputes. So, Raid, shall we start with you first? You have about 5 minutes time. Thank you.
Yes, it's not a lot of time, but I'll try my best. So this desire for harmonization, and I noticed Domenico was referring to an article by Roy Good, and in that article, Professor Roy Good was referring back to this desire to harmonize, which goes back even to the days, and this is appropriate given you, and we have you and Domenico with us, back to the days of the Roman Empire, where Cicero wrote in De Republica. He wrote about that there will only be one law, in essence, Roman law. And we're not quite there yet, but this idea of having one law, soft law, goes back over 2,000 years ago. And so when I was taught by Professor Roy Good about over 20 years ago, put it that way, he was explaining to us how important it was to have soft law in international trade. We were talking about letters of credit. We were looking at the USB, Universal Commercial Code for letters of credit, how it is applied. And so it was clear that that soft law and standard terms, practice and customs, they go hand in hand to facilitate international trade, to facilitate international business. You cannot have one without the other, because you cannot agree between different countries, so many countries, one set of laws. And so, what you end up agreeing with is certain standard terms, but behind it and all around it, there is a huge amount of soft law, customs, practice. And this is, we see that virtually in everything, every part of international business transactions, wherever you are. You see that you have a core, you have the standard terms, but around it you have a universe of soft law. Now, I'm just going to look at one particular example, which is relevant to what I do on a daily basis. We see quite a lot of in the infrastructure space. We see quite a lot of ICC arbitrations. So when most of the world opts for ICC arbitrations in infrastructure disputes, and that's because of the ICC and how the ICC spread around the globe. And a lot of the infrastructure development takes place in more developing countries, and they end up using the ICC. But one of the main reasons for that is in the FIDIC contracts, which are the fundamental basis for infrastructure development agreements all around the globe. The ICC rules are recommended, and so everyone uses also the ICC. So that's an example of a standard term that ends up with your link to the dispute resolution, ends up with the ICC. So when you sign a FIDIC contract and you say you signed you're doing a power plant somewhere in the Middle East, say. Very common. You have say a Korean contractor. You have equipment that is purchased from the US, and then you have say a local party. And so how can they? And they have their arbitration locally, so not in some established international center. So how do they go about proceeding? So you end up in terms of the standard terms, which are included in the FIDIC contracts, for example, you end up with very similar terms. For example, who takes the risk for the ground conditions? What happens if there's a dispute during the execution? It ends up going to a DAB. That is a standard term which embedded within FIDIC, which is then is used all over the world, and it's a sort of norm, it's a practice that is then applied. Then how do you deal with claims? There's some strict conditions on time bars in relation to notification of claims that are often found in FIDIC. So these are an example of the standard terms, but then around them, once you end up in a dispute, and unfortunately you end up in quite a lot of disputes in infrastructure work, so this is an area of a lot of work for people who do international arbitration. So when you end up in a dispute, when you start looking at appointing the panel, you then look at the appointment, and then you will find that the IBA rules, and the IBA has done an amazing job, particularly the International Arbitration Committee, in setting out the IBA guidelines. So the IBA guidelines on conflict of interest, followed by the IBA rules on taking evidence. They then become an embedded part of the arbitral process, because particularly in more developing countries where laws are yet to catch up, you find that there's often a lacuna as to how you're going to apply, how you're going to find existing practice, and you end up falling back on the IBA rules. So in terms of 60% in the great survey that Queen Mary conducts every year, 60% of people said that the rules on conflict of interest in relation to arbitrators are used and applied. That's an example of soft law that is, whilst it's not in a sense a standard term, it is essentially it becomes something that is used. It almost is akin as if it is a standard term. And sometimes you find the IBA rules, for example, on taking evidence, actually embedded within the arbitration clause, i.e. it's used, it's referred to as a guideline. So this is an example of how you have a scenario where you've got standard terms, so you've got the FIDIC, and then around it you've got everything when it comes to dealing and resolving the dispute. You have all around it the soft law that it ensures that the dispute proceeds in a satisfactory manner and leads to proper resolution. So I don't know whether that's sort of illustrated within, I don't know how many minutes I did, but probably more than 5.
You did well.
Okay.
You did well, both in terms of the substance of your response and also of time management. Thank you very much, Raid. So I understand that there are definitely some sort of complementarity between the two. And I would like to ask Domenico to share his thoughts, maybe a different experience or similar experience on how he perceives the relationship between the two.
Well, thank you, Andromachi. And I entirely agree with Raid, and actually he gave an excellent overview of soft law and how soft law interacts in international arbitration. And if I may possibly focus on 2 slightly different aspects. One is more the relationship between arbitration and court proceedings, litigation and court, and the different treatment that is given to soft law in arbitration compared to litigation. I saw your question, and I think the relationship is definitely a companionship. Possibly the answer might have been different 2 or 3 decades ago, when still we had instances of friction or, let's say, inability to interact. Modern arbitration laws have turned the relationship into something extremely positive. And speaking of harmonization instruments, the ancestral model law has performed wonders in their respect. And even recently, the restatement of the US law of international commercial and investor state arbitration is another example of this modern approach to arbitration. Nowadays, courts are there to support and even to protect arbitration as a recognized leading means for the resolution of transnational business disputes. And also, courts are increasingly deferential to the finding of arbitral tribunals, both at the stage of annulment proceedings or when it comes to the enforcement of an arbitral award rendered abroad. And another indicator of this positive relationship is the fact that several jurisdictions have recognized the need to have specialized sections of their courts focusing on international arbitration related court proceedings. So definitely a relationship or companionship. As regards the second aspect, the different treatment, yes, the short answer is yes, soft law does receive different treatment. Indeed, one may even venture to say that soft law thrives in international arbitration, where it finds it the perfect environment. I want to make two points, if I have a couple of minutes. From a theoretical point of view, soft law and international arbitration are genetically very similar, and both of them have been developed to address the needs and concerns of transnational business communities. And soft law instruments are viewed as neutral because they reflect trends and views that have not been formulated by government. And at this point was made very clear by the late Professor Alan Farnsworth, and he served both as an American delegate to the negotiation of the CSG, the Vienna Convention on the Sale of Goods, and as a member of the working group of UNIDROIT for the creation of the UNIDROIT Principles of International Commercial Contracts. In his article, The American Provenance of the UNIDROIT, he made it clear that the atmosphere during the negotiation of the CSG at Antitrust was very much political, because those attending were representative of the government and had a political agenda in the negotiation of the CSG, while at UNIDROIT that was not the case, because participants appeared in the private capacity. Then that was the theoretical introduction. With regard to the practical standpoint, the broader application of soft law in international arbitration is the result of normative and structural peculiarities. From a normative point of view, one of the best known features of arbitration, as opposed to court litigation, is the broader discretion granted to arbitrators for the identification of the law or the rules of law applicable to the substance of the dispute. Arbitrators can proceed in a way that generally is precluded to national courts, and arbitrators can disregard contract of law rules and adopt a more flexible approach in identifying the rules of law applicable to the dispute. Most arbitration rules provide that in the absence of choice of law by the parties, the arbitral tribunal shall apply the rules of law, so not even necessarily a law, which it determines to be appropriate. And in any event, arbitrators are expected to take into account trade usages. The emphasis is always on the transnational nature of the dispute, and the transnational, if I can use this expression, the transnational expectation of the parties. One last comment about the structural peculiarity, and this is something that sometimes might be controversial, but let us not forget that most international arbitral tribunals are composed predominantly by arbitrators from different countries and not qualified in the law applicable to the substance of the dispute. So the natural tendency is to give priority to the contractual provisions to be interpreted in line with the international practice, accepted soft law principles, and trade usages. Arbitrators are mindful of this expectation of the parties and conduct themselves accordingly. Raid mentioned the IBA rules, the IBA guidelines. Those instruments are invariably present in every arbitration that I do, and either as guidance to the arbitral tribunal or as a binding instrument when the parties so agree. And this approach is respected, and we all are aware of a judgment by the French Court of Appeal earlier this year, which upheld an ICC award where the arbitral tribunal applied, in the absence of choice by the parties, as lex contractus, the UNIDROIT principles of international commercial contracts. And according to the French Court of Appeal, that was entirely proper, and the award was upheld.
Domenico, thank you very much. Lots of takeaways. Perhaps if I could highlight two of them. The first one is the impact of international harmonization over the years to smooth out, if you like, any points of tension between the two, perceived points of tension. And on the other hand, what you said and tried to explain in greater detail about the fact that soft law tends to receive different treatment in arbitration, not least because arbitrators are endowed with broader discretion. So now I would like to move on to Sam and ask his take of the relationship between the two, and especially if we see this relationship through the lens of litigation.
Absolutely, yeah. I'm going to pick up on something Domenico said actually about the increasing amenability of courts also to soft law. And speaking from an English lawyer's perspective, one may naturally assume that arbitration is far more amenable to soft law and it has more of a relationship of companionship. But what I've noticed since my time in practice is that actually soft law is more influential even in a black letter law process like the English courts than you may think. And I think that one of the reasons for that is also to do with internationalization. The English courts now are very, very aware of their use by large international companies, particularly the commercial courts, of course. And you'll see, I'm not sure of the exact figures, but many cases now have no English parties at all, or no English companies. They are in the English courts, but they are contested by two companies or two entities from entirely different jurisdictions. And so what you see is an increasing awareness from commercial court judges of the English law in its context in an international setting. So even though perhaps the trend in English courts in the last 5 or 6 years is towards a more literal and textual approach to the interpretation of contracts, that approach does still sit in the international commercial setting, not in its entirety, but to a great extent. And I thought maybe to illustrate that point, I'd take a couple of very well-known English cases. And the first one, quite a recent case of rock advertising, which considered non-oral modification clauses, which was something that was ambiguous in English law until relatively recently, but they weren't ambiguous in international law, generally accepted in many jurisdictions, and also UNIDROIT principles propound a non-oral modification clause in their terms. So what you see is during that hearing, all the way up to the Supreme Court, of course, the judges were aware of that, and several of them actually quoted and said, well, we think we should now recognise non-oral modification clauses, partly because in the international setting, they're a norm, and we need to normalise our process, given that now much of our commerce sits in an international setting. And similarly, another case would be very well known, Cavendish and McDessie with the law on penalties. Once again, there was one of the advocates was saying, well, I don't think we should have a law on penalties at all anymore. Commercial parties are so sophisticated. Why would we intervene if that's the breach and the response to that breach is agreed? We should not be judging whether that is a penalty. But once again, the judges in that case said, in fact, you'll see penalty clauses in the UNIDROIT principles and in other jurisdictions, and we've also recognised that we want to retain something similar. So once again, although UNIDROIT is of course soft law, it was very much influential in those decisions. And I think probably an even better example perhaps is the emerging, or really now emerged, concept of good faith in English law. Not something traditionally recognised, but it's ever increasing in its importance. And that's because I think so many other jurisdictions, particularly civil law jurisdictions, recognise good faith in contracts. And so what you see is good faith terms coming into English commercial contracts, but in quite broad terms, and they will of course refer to a standard. And in judging good faith, you always have to refer to some sort of standard, but that standard is invariably a soft law standard. So where we now have good faith permeating many cases, and many recent cases, particularly the post office case of late, which is very well known, of course, that you do see very important points of law decided largely by reference to standards which are based in soft law.
Thank you very much, Sam. I think that you're raising a very important issue there, which is the increasing awareness of judges, especially in the UK, of the transnational setting of commercial business, and by implication how we interpret and how we understand the law that applies to the dispute in question. I think that's a very interesting thread, in the sense that who knows, if it continues in the future, we may end up observing a sort of convergence in the treatment of soft law and standard contracts in arbitration as well as in litigation. Maybe the differences in the treatment will become less pronounced in the future. I mean, we don't have the crystal ball, obviously, but just to make the point that this is a very intriguing trend to watch, how it will evolve in the future. Now, talking about the future, I'm wondering whether the relationship between soft law and standard contracts, and their importance too, will change as a result of technological developments. So I guess my next question, or rather set of questions, is the following. Is technology changing the relationship between the two? Are we going to see, for example, an end of soft law in the future, as everything arguably will turn into code and algorithms? And how is technology changing procedural aspects of international commercial litigation and arbitration that might have an impact on, how we perceive the importance between soft law vis-a-vis standard contracts in the future? Domenico, could we start with you first?
Of course, thank you, Andromachi. And that's a very, very interesting question. I start from the assumption. I mean, the first question can be summarized as, is it the end of soft law? And soft law institutions are always at the forefront, and structurally, they are better equipped to foresee and tackle the developments in international trade. And soft law instruments can be adapted to a developing environment, to a changing environment much more quickly and much more efficiently than domestic or international legislation. And also, because soft law instruments are drafted by experts, they are more likely to tackle the new environment more efficiently. And let me give you a couple of examples. UNIDROIT has worked extensively in the area of contract law and has adopted a variety of soft law instruments intended to offer harmonized and effective rules to respond to the evolving needs, to a world that keeps changing. And earlier today, I mentioned the UNIDROIT principles of international commercial contracts, which were published in 1994 and have been updated 3 times since then. Another example is the successful, enormously successful, and frequently updated collection of Incoterms published by the International Chamber of Commerce. Incoterms provide internationally accepted definitions and rules of interpretation for most common commercial terms used in contract for the sale of goods. And they remove uncertainties arising from different interpretations that you may find in different countries and different jurisdictions. And as such, they're regularly incorporated into sales contracts worldwide. And the first work published by the ICC on standard terms was in 1923, even though the first edition of so-called Incoterms was in 1936. Well, since 1936, the ICC updated, modified the Incoterms 9 times, and the latest edition came out in September last year. So soft law is more flexible and more likely to adapt to new scenarios. Imagine doing the same, Andromachi, with the CSG, or imagine doing the same with the New York Convention. It would be impossible. And so also we need to take into account the respect that political agendas slow down the domestic international normative process. And this is why, for example, it took almost 10 years to finalize the CSG. And also soft law instruments have the advantage of not needing ratification, that, some instruments are negotiated, hard law instruments are negotiated, but it takes sometimes many years for these instruments to be ratified. Imagine the New York Convention was signed in 1958, but the U.S. only ratified the New York Convention in 1970. So I see your point, but I believe that what is likely changing is how soft law is going to be created. Algorithms might be used to analyze collected data to identify trends in international business more efficiently and more quickly. So soft law will not die. In fact, I believe that soft law will become much stronger because of the structural ability to address changes.
Very interesting points. Thank you very much, Domenico. Maybe we should have a separate discussion on that on a research-related theme at some point.
One thing that I wanted to add, if I have just a few seconds, there was another aspect of your question is how technology is changing the procedural aspects of international arbitration. And very short, this is almost political, but arbitration has been vilified many times, citing to the alleged time and cost inefficiencies. Arbitration is not perfect, of course, but most of the time, criticism has been the result of limited knowledge of the phenomenon, or I must say, political agenda. You can, of course, accuse arbitration of being slow, but if you do that, you forget that arbitration works like a car. How fast and efficiently it runs, it depends on the wishes of the driver. And the immense advantage of arbitration is being fully appreciated during these social distancing times. Most of the procedural activities have not, in international arbitration proceedings, have not been affected by the difficult situation that we all are experiencing right now. We are filing documents electronically, we are filing briefs electronically, and this is an amazing advantage that arbitration would offer. And I do understand that also some very well organized courts in a number of jurisdictions are adjusting their practices to address the situation, but arbitration had this advantage. It was there, and everyone doing international arbitration was fully prepared to tackle this situation.
Thank you. Now I'm realizing that we are shortly running out of time, so to allow about 8 to 10 minutes for Q&A from the audience, and I would like to encourage members of the audience to submit any questions they might have on the Zoom chat. Could I have a brief reaction response from Sam, and then from Ryan, and then we will take some questions from the audience. Sam?
Sure, yes. I agree with Domenico. I don't think algorithms and artificial intelligence are a particular threat to soft law, and I'll explain why for slightly different reasons, or for slightly different perspective at least. When we practice as lawyers in Mayer Brown, we often receive presentations from companies advertise very, very advanced search engines that can narrow your documents down from millions to thousands by applying a complex series of algorithms, which I can't pretend to understand, but all of them are offering you supposedly much more certainty. And you might think that in that context, where something can give you a right or wrong answer, why do you need the guidance of soft law necessarily? And that's perhaps where the idea of the threat comes from. But I think the problem with that lies very much in the algorithm's tendency to look for a right or a wrong answer, a black or a white distinction, because law is, of course, it's an art and not a science, and you don't have very often these clear distinctions. And I think that's where AI, in my experience, continues to be very limited. And that's why I think I don't see so much of a threat to my profession, I suppose, in itself, but also to soft law and then a huge role that plays within it. And so I perhaps would give an example of something like a tax system with clear brackets, and if you earn this much, you pay this much. That to me is very amenable to an algorithmic approach, because it's very clear boundaries, very defined, and some complex calculations can be much better done by a computer than by a human being. But when you have something like, for example, a rule, which is a firm rule, but what happens when it's applied in a new and changing context? And the application of that rule in the new and changing context leads to a very unjust result. Now, you need there the most important thing, perhaps in a judge or an arbitrator's repertoire, is discretion. You have to be able to see the nuances and perhaps come to a different ultimate result, however, based on the same rule. And what I don't see at all is any kind of artificial intelligence or algorithm that can appreciate that approach and the distinction and the critical and clarity of thought that's necessary to go through that process. And soft law within that, of course, is vital, because guiding that discretion, behind that discretion, is a whole body of soft law rules, whether that be ICC rules, UNIDROIT rules. The Convention for the International Sale of Goods is another one that I've come across as a reference point for an arbitrator. I don't see really how algorithms and AI can do that as well as the human experience can.
I see. Excellent example. I think it shows very well the difference between using technology as an instrument to inform judgments and rather than replacement of human intelligence, which is a general intelligence as opposed to the specialist intelligence of computers and machines. Raid, any brief comment, anything to add? We have questions from the audience and limited time to address them. Thank you.
Sure. Well, just very brief. The way I see technology and international arbitration, I think they go again hand in hand. They're actually mutual friends, and the reason is what we today is an example of how technology facilitates communication. And communication, international communication, is key for international arbitration. The fact that you can now conduct hearings remotely just demonstrates how international arbitration sits in very well with technology. So technology facilitates international arbitration. It brings people together even in circumstances of COVID-19 where people cannot travel. Technology is helping international arbitration, helping the process go forward, helping hearings go forward. Different protocols, we know the SOL protocol, video conferencing, for example, is an example of a soft law, a soft law that is being developed to facilitate how evidence can be obtained via video conferencing. We see that the same by all the major institutions. They've all come up with protocols to deal with hearings, all using technology. So technology is a great weapon for international arbitration, for soft law, for harmonizing and bringing international dispute resolution together under one umbrella and one standard. So I don't see them. And the other one is we got the new arbitrator intelligence that is being that also uses technology to determine suitability of arbitrators. So all in all, I think they sit together. They're not inconsistent, and technology, I think, will lead to strengthen international arbitration and with it soft law. So not inconsistent at all.
Thank you very much. I'm moving directly to questions from the audience. Thank you very much for submitting your questions, by the way, and for joining us this lunchtime. So question number one, let's see how much time is left to respond to all the questions. In your experience, what is the importance of transnational private regulation, ISO, ASTM, American Gas Association, and other standards in the construction, oil, and mining industry in arbitration? It is addressed to all of you, but if anyone would like to respond to this question within 2 minutes, please, because there is another one and perhaps a third one.
I think
right?
Yes, just answering very, very quickly, because I wasn't on mute, so I thought I'll jump in. I think that it clearly transnational private regulation forms when you have an international tribunal and it's looking to apply guidelines, it's looking to establish yardsticks, measures. It's by its nature being an international forum, it will look to international standards, and that it'll look to them as some sort of soft law, but it'll look to them because they might also be brought in under the contract, because of course the contract might say might refer to the application of international standards, whether it is in the oil and gas industry, which often refers to the use of international standards, or it is in, for example, how do you measure whether the proper execution of work, say, in an infrastructure project. You will look to see what international regulations say.
Thank you. Question number 2, again, addressed to all of you. Will you please comment on how much the Singapore Convention on Mediation is being considered in your milieu and recognized as a tool to be increasingly used in cross-border litigation? Who might go first?
Do you want me to say something about that?
Please do, since you have your microphone on.
Well, I think it certainly is being considered, actually. It is being considered. I mean, we've had cases where we have been referring clients to the convention, but I don't think I've ever yet seen it actually be implemented. But I think practitioners, international arbitration practitioners, are aware of it, and it is a fantastic source, because I think at the end of the day, where mediation is extraordinarily important, and the fact that you have an international convention on it, I think is very useful, particularly as not every culture is used to dealing with the formal mediation process. So we have seen it. It is being mentioned, but nothing has yet been applied.
Thank you.
Andromachi, I can confirm what Raid just said. I think the convention is giving mediation much more legitimacy in international dispute resolution, and obviously it's a great tool that goes hand in hand with international arbitration.
Well, that's very interesting, the legitimacy angle into this. Sam, your thoughts?
Yeah, I agree with both Raid and Domenico. I think from the English law perspective, mediation is being increasingly encouraged all the time, and there's actually now sanctions for failing to mediate, and clauses which were perhaps only advisory in contracts about friendly negotiations before embarking on the dispute resolution process, which used to not really be enforceable, are now, of course, enforceable. So that shows the increasing prominence of mediation. I haven't encountered the Singapore Convention myself, although I've of course heard of it, but I think it's going to become more and more prominent, because mediation just makes sense on so many levels, given the potential time and cost involved in a formal dispute. And I think it's so favoured and viewed in a light which can save so much cost and time that I think the Singapore Convention will become something which is signed up to by many more nations.
Thank you. And one final question from my audience. The question is the following. I would like to know how relevant is arbitration in developing countries, and I think that's an excellent question. And if I can ask each one of you for a brief response, because we have 2-3 minutes left. Right? Can we start?
Yes, yeah, just very quickly. I think I'm just looking at it from the Middle East. In a sense, arbitration started as the view in the Middle East as it is the enemy of developing countries, because it's basically a sort of Western process being imposed on developing countries that haven't got yet experience, nor do they have arbitrators, for example, from those countries. So you're getting, let's put it very crudely, Western arbitrators ruling on developing law issues, etc. And sort of the result is always almost prejudiced, always against them. So that was the thinking. But now I think increasingly, I think everywhere, arbitration is highly relevant, because as well as providing more and more a neutral place, and I think you need to have more arbitrators from developing countries, and I think that is really, really important that takes place, including ensuring diversity of arbitrators generally. It is being used, as I see it, and it has been used now as a weapon. I've seen many developing countries, whether they are acting as investors or whether they're trying to deal with a commercial dispute, actually use arbitration as a weapon in order to recover their entitlements, in order to deal with their problems. So I think the key is, almost for developing countries, is to ensure that arbitration is the guidelines to arbitration. There is training, and it sort of permeates the legal community, and there's an understanding of it, and including clients, because it can be a shield and it can be a weapon, and I think it's a way of achieving actually fair resolution.
Thank you, Domenico. Very briefly, your thoughts?
I know, but I'm aware of that. I mean, it's an excellent question, and one that maybe deserves an entire webinar by itself. And I think that if I could, somehow follow up on what Raida just said, is we are moving in developing countries from the age of acceptance of arbitration, more generally international arbitration, to an age of full involvement. And there, I believe that is the task for the international arbitration community, to make sure that all countries are represented, and we have more arbitrators from developing countries. So that is the target, and that should be our goal these days.
Thank you, Domenico. Sam?
Yes, I agree with both Domenico and Raid again. I think I practiced in Southeast Asia for 5 years, and I saw that kind of transition whereby arbitration was used very much as a tool to attract international investors in business. I was based in Thailand, and I went to several of the seminars of the Thai Arbitration Institute, and they were very often saying that we appreciate there is some doubt about the partiality of our court process. In your international contracts, you can select Thai arbitration if you're prepared to do so, and you will have a very impartial, fair, transparent process to facilitate your business and progress what you're perhaps manufacturing or minerals, or all the things that are available to do in Thailand.
Thank you very much. The time is 32 minutes past 1, which means that we have run out of time, I'm afraid. So I would like to thank Ray, Domenico, and Sam for the excellent points, the insightful reflections on the theme of this webinar this lunchtime. Great having you this afternoon, and also to thank everyone for joining us and for the intriguing questions. I hope that next time we will be celebrating with a glass of wine properly, and I hope you all keep safe and have a lovely day ahead. Take care.
Just one final comment to mention. Yes. What an excellent chairperson we've had, I think.
Absolutely.
So I think
thank you very much. Well
congratulations
done. Thank you very
to you
much.
as well.
Thank you very much.
Thank you.
Let's do it again at some point.
Yes, definitely. Thank you.
Thank you.
Bye.
Bye.
Bye.